everyone. I'm Justin Piper from Granite Trademark Services, and I'm here today to talk about likelihood of confusion. And in particular, what does an examining attorney at the United States Patent and Trademark Office think about and discuss and analyze when he's trying to make a likelihood of confusion analysis between your potential application and somebody else's registration that's already on the United States Patent and Trademark Office Principal Register. So let's just get right into the factors. These factors are called the DuPont factors. They come from an older case, but the factors are still relevant, and these are the factors that are given to the examining attorneys at the USPTO to look at and think about if they ever catch any marks that may be similar. So let's just start with the first factor of the DuPont factors, and it is the examining attorney will look at the similarity of the marks. And that means, does the trademark application and is there a trademark on the register that looks similar, sounds similar, have a similar commercial impression and a similar connotation. So in other words, do the trademarks look alike when you just look at them on a piece of paper? Do they sound alike when you say them out loud? So just because things are spelled differently doesn't mean that the words are pronounced differently. For example, you can spell armor A-R-M-O-U-R or A-R-M-O-R, and it's both armor. So for trademark purposes, it's going to be treated as the same word because they sound the same, and even though they don't look identical, they sound identical. So that's the first place to look. So if the marks are not similar and there's no similar marks to your application on the trademark registry, the examining attorney can just move on to the next step of his process. But say there is a mark that's kind of similar or maybe even the same as your trademark application, the trademark examining attorney will go on to the next step, which is they'll analyze the relatedness of the goods and or services. So if you have a company name such as Granite Trademark Services and someone has a company name called Granite Bank Services, they should be able to both coexist because banking services and lawyer services are different, and ultimately no one's going to be confused walking into the bank thinking they're going to get a lawyer. So basically, it's would a consumer see the two trademarks together, see how related the goods are, and think, are they the same company or are they related? Are they like cousins or something? So that's the basic kind of analysis just from a high level perspective. So you look at how related the marks are. Do they sound, look, present the same kind of commercial impression? And then you look at the goods and services, and are they similar? Are they related? Are they completely different? Are they somewhat related and somewhat not? So if they're very similar, the goods need to be very dissimilar. If their trademarks are kind of different but somewhat similar, then the goods can be a little bit closer together. And this is all very subjective. It's why people argue and people hire lawyers to litigate all these things. It can get pretty complicated and pretty in-depth. Just with those two factors, just the main two factors of what does the trademark look, sound, feel like, and what are the related goods and services. If you can't come to a decision based on those factors, and you rarely ever can, especially if it's a yes, they are likelihood to cause confusion, some other things the examining attorney will look at is what are the trade channels that these goods are sold in. For example, do you sell your product in a supermarket and it's just something that's there and people just grab it when they're exiting the aisle, or is it something that costs thousands and thousands of dollars like a car where the consumer is likely to think about it before purchasing and do a lot more research than just the impulse buy at the store? So that's one thing they'll look at is how sophisticated the customer is. So for expensive purchases, things that are complex will be more sophisticated. They'll be less likely to be confused as the person just walking by and grabbing something off the shelf. Another thing that a trademark examining attorney might look at is like, okay, these two trademarks are somewhat similar, but there's 20 other people with similar trademarks, and if those 20 other people can coexist and there hasn't been an issue, then what's the difference between making it 21? So that's something else, the number of similar trademarks and those goods and services that they're related to. So if there's a lot, it's considered a crowded space, and there'll be less trademark protection given to any one of those trademarks. And lastly, if you file for a trademark application, there's a federal registration already listed. The examining attorney might say, I just don't really like it with this out there. And maybe you've known about this trademark registration and you already have an agreement with that trademark owner saying, hey, before I file this application, I just want to make sure that there won't be any issues with you. So can you just sign this consent agreement that we've both been doing this, that we agree to both have the same trademark? And that will usually be enough for the examining attorney to accept and pass your trademark application on to the next phase. If you have any questions about likelihood of confusion, especially at the USPTO level, feel free to leave a comment or contact us at Granite Trademark Services, and we'll get back to you. Thanks. Bye.